Before we begin, a critical disclaimer. I am not a lawyer, and the information in this video does not constitute legal advice. This presentation is for educational and informational purposes only. My goal is not to provide you with legal answers, but to empower you with the right questions so you can find a qualified professional who can. Please consult with a licensed attorney for advice on your individual situation. You walk into an office that smells like old leather and ambition. Across a mahogany desk sits a person in a perfectly tailored suit, surrounded by walls of intimidating-looking books. Your heart is hammering against your ribs. Your mind is racing. You know you need help, and you know this person might be the only one who can provide it. But there's a clock on the wall, and you know that every single minute you spend in this chair is costing you money you probably don't have. You feel small. You feel powerless. And you're about to make one of the most important financial and personal decisions of your life, completely in the dark. This single meeting, this 1-hour consultation, can be the difference between a successful outcome and a complete nightmare. It can be the difference between finding a true advocate who fights for you and hiring someone who sees you as just another billable hour. The terrifying truth is that hiring the wrong lawyer is often worse and far more expensive than having no lawyer at all. A bad lawyer can miss deadlines, fail to communicate, and make critical errors that can haunt you for years. They can drain your bank account while your problem gets worse. And the worst part? Most people don't realize they've made a catastrophic mistake until they're thousands of dollars in and months, or even years down a dead-end road. But what if it didn't have to be that way? What if you could walk into that room, take a deep breath, and feel not fear but control? What if you had a secret weapon? A set of 5 questions so precise, so insightful, that they could instantly cut through the sales pitch, expose the red flags, and reveal the true character and competence of the person sitting across from you. That's exactly what this video is going to give you. We're not talking about the obvious surface-level questions like, what are your fees? Or, how long have you been practicing? They expect those. They have canned answers for those. No, these are surgical questions. These are the questions that make a great lawyer light up and a bad lawyer squirm. By the end of this video, you will have a powerful toolkit that will transform you from a nervous victim into a prepared, confident consumer, ready to hire the right person to fight for your future. So let's get into it. The first essential question you must ask is not about their wins or their law school. It's about the single biggest point of failure in the entire legal industry. It's the #1 complaint clients file against their attorneys, year after year. The question is this: beyond your legal expertise, what is your firm's specific process for client communication and case management? Now let that sink in for a moment. Notice the wording, beyond your legal expertise. This is key. You're sidestepping their ego. You're essentially saying, I'll assume for a moment that you know the law. Let's talk about what really matters to me, the client. How are you going to treat me and my case for the next several months or years? This question is a brilliant diagnostic tool because it forces them to talk about their systems. And let me tell you, elite professionals have systems. Amateurs wing it. A great lawyer, a true advocate, will love this question. Their face will light up. They'll lean forward and say something like, that's an excellent question. We pride ourselves on our communication. Here's how it works. You will be assigned a primary paralegal, Jane, who will be your day-to-day contact for all non-legal status updates. This keeps your costs down as you're not being billed my hourly rate for a simple question. We use a secure online client portal where you can access all your case documents, see upcoming deadlines, and send us messages 24/7. Furthermore, you can expect a detailed email update from me personally at the close of business every second Friday. Even if there's no major news, just so you know we are actively working on your case. For any urgent legal matter, you'll have my direct cell phone number. Do you feel the difference? That's a green light answer. It's specific. It's systematic. It demonstrates respect for your time, your money, and your peace of mind. It shows they have thought deeply about the client experience. They have a plan. They have a process. They aren't just reacting to problems. They have built a structure designed to prevent them. This is the answer of a professional who runs a business, not just a law practice. This is the person who understands that legal victory is meaningless if the client feels ignored, confused, and stressed out for the entire journey. Now let's look at the flip side. The red flag answer. You ask, beyond your legal expertise, what is your firm's specific process for client communication and case management? And the lawyer leans back. They might look a little annoyed, a little surprised you're not asking about their last big courtroom win. They might give you a vague, dismissive, or even defensive response. It sounds like this: "Don't worry, we'll keep you in the loop. We have an open door policy. Just call the office whenever you have a question. My assistant, she'll probably pick up. Look, you're hiring me to worry about the legal stuff so you don't have to. When something important happens, you'll hear from me. No news is good news." This is a 5-alarm fire. "No news is good news" is the most dangerous phrase you can ever hear from a lawyer. It's code for, "I'm too busy for you," or "I don't have a system, so I'll just call you when I feel like it." It creates a black hole of information where your anxiety will fester. Vague promises like "we'll keep you in the loop" are completely meaningless. It shows a fundamental lack of respect for your role in the process. It's your life, your money, your future on the line. You deserve a clear, predictable, and professional system for communication. A lawyer who gets defensive about this question is revealing a critical weakness in their practice. They are telling you right to your face that their client service is an afterthought. This is the lawyer who will disappear for weeks, who won't return your calls, and who will send you a massive, surprising bill for miscellaneous communications you can't even remember having. Think about it this way: you wouldn't hire a contractor to build your house if they said, "Don't worry, I'll let you know when it's done." You'd want blueprints. You'd want a schedule. You'd want regular check-ins and progress reports. Your legal case is the house your future will be built on. It demands the same level of professional project management. So, this first question isn't just a question. It's a test. It's a window into their soul as a service provider. It separates the organized, client-focused professionals from the chaotic, ego-driven gunslingers. And it's the first, most critical step in taking control of the hiring process and ensuring you find someone who will not only fight for you, but will respect you every step of the way. Now let's get this straight. When you walk into a lawyer's office for the first time, you are not a patient waiting for a diagnosis. You are a CEO conducting a job interview for one of the most important positions your life or business will ever have. You are hiring a guide to lead you through a dense, dangerous, and expensive jungle. Would you hire a guide who grabs your money, points vaguely into the trees and says, "Follow me, don't ask questions"? Of course not. You'd want to know the route, the plan, the communication protocol, and what happens if you run into trouble. Yet thousands of people every single day walk into a law firm, intimidated by the fancy degrees on the wall and the expensive suits, and hand over control of their fate without asking the most basic, fundamental questions. Let me tell you a story about a man we'll call David. David owned a small, successful software company. He had a dispute with a vendor over a 6-figure contract that went sideways. It was stressful, but it seemed straightforward. David did what most people do. He Googled business litigation attorney, found a firm with a slick website and 5-star reviews, and booked a consultation. He walked into the meeting and met a lawyer we'll call Mr. Glass. Mr. Glass was everything you see on TV. Sharp, confident, a little arrogant. He talked a big game. He used words like dominate, crush, and unacceptable. He assured David that they would file an aggressive lawsuit that would have the vendor begging to settle. David was impressed. He was scared, and Mr. Glass's confidence felt like a shield. So he wrote a massive check for the retainer and signed the engagement letter, feeling a wave of relief. He had a shark on his side. The first month things were great. Flurries of activity, documents filed, a sense of momentum, then silence. David would email Mr. Glass for an update and get no reply for a week. When he called, he'd get a paralegal who would say, "Mr. Glass is in a meeting, I'll have him call you." The call never came. 2 weeks later, another email. Finally, a short, one-sentence reply that answered nothing. The anxiety started to creep back in. David felt completely in the dark. He had no idea what was happening in a case that was costing him thousands of dollars a week. Then the bill came. It was a masterpiece of opaque billing. Line after line of legal research, document review, inter-office conference. He was being charged a fortune for work he didn't understand and for a strategy he was never consulted on. He finally got Mr. Glass on the phone, his voice tight with frustration. He asked what was going on. Mr. Glass was dismissive. "David, you hired me to handle this. Let me do my job. These things take time." He made David feel small, like he was a nuisance for wanting to know what was happening with his own case with his own money. The case dragged on for 18 months. The initial straightforward dispute had ballooned into a monstrous legal war, fueled by aggressive tactics that only served to enrich the lawyers on both sides. David spent over $150,000. He ended up settling for an amount that was only marginally better than the vendor's very first offer. He lost a year and a half of his life to stress, he neglected his business, and he burned through his savings, all because he was a passenger in his own legal journey. David's mistake wasn't hiring a bad lawyer. Mr. Glass was probably a very competent legal tactician. David's mistake was hiring the wrong lawyer for him. He hired a gunslinger when he needed a guide. And he made this mistake because he was so focused on the lawyer's perceived aggression and confidence that he failed to interview for the single most important factor in a healthy attorney-client relationship: communication. This brings us to the very first non-negotiable question you must ask in your first meeting. And you need to listen to the answer with laser focus, because it will tell you almost everything you need to know about what it will be like to work with this person. The question is, what is your communication policy, and how will I be kept informed about the progress of my case? Now, this question is a finely tuned instrument. Notice the specific words. It's not, will you keep me updated? A simple yes answers that. It's not, how do you communicate? That's too open-ended. You are asking for their policy. That word policy is key. Policy implies a system, process. It implies that they have thought about this problem before and have created a standardized, professional way of handling it. It separates the pros who have built a client-focused practice from the disorganized solo practitioners who are just winging it. A bad answer, a massive flashing red flag, sounds like Mr. Glass. It's vague, dismissive, and puts the burden on you. It sounds like this: oh, don't worry, we're great at communication. We'll call you when something happens. Or, just send me an email if you have a question. Or the worst one of all: my paralegal handles most of the client communication. These answers signal that they see client communication as a chore, a distraction from the real legal work. They tell you that you will spend your nights wondering what's going on. They tell you that you will have to chase them for information. They tell you that you are not a priority. If you hear an answer like this, thank them for their time, walk out, and never look back. A good answer, the answer you are looking for, is specific, detailed, and reassuring. It demonstrates a system. It sounds something like this: that's a great question. We believe informed clients are the best clients. Here's our policy. First, within 48 hours of retaining us, you'll receive access to our secure online client portal. Every document we file, every letter we receive, every key date is uploaded there in real time. You can log in 24/7 and see the exact status of your case. Second, you will receive a mandatory summary email from my team every other Friday. Even if there are no major developments, this email will confirm the current status, what we're waiting on, and what the next steps are, so you're never left in the dark. Third, for routine questions about scheduling or document collection, my paralegal, Jessica, is your primary point of contact. She's fantastic and bills at a much lower rate, which saves you money. For any strategic questions or urgent matters, you contact me directly. My policy is to return all client calls and emails within 1 business day. If you haven't heard from me by then, you can call my direct line and know that it's an urgent priority. Do you feel the difference? It's night and day. That is the answer of a professional who has built their practice around the client experience. They understand that legal issues are incredibly stressful, and that silence is the enemy of peace of mind. They've created a system that provides transparency, predictability, and control. They respect your money by using lower-cost staff for appropriate tasks, and they respect your intelligence by giving you direct access to the case file. They are setting clear expectations from minute one. An attorney who can give you an answer like that is not just a legal technician. They are a business owner who understands customer service. They are the guide who, before you even step into the jungle, hands you a map, a compass, and a radio and says, "We're in this together. You will always know where we are, where we're going, and how to reach me." Getting clarity on communication is the foundation of the entire relationship. But knowing how they'll talk to you is only half the battle. The next question uncovers who will actually be doing the work on your case, and the answer can be the difference between expert guidance and paying a premium for an inexperienced associate to learn on your dime. This brings us to the second and arguably one of the most crucial questions you can ask, a question that peels back the curtain on the business of law itself. It's a question that can save you thousands of dollars and an immeasurable amount of frustration. That question is, who specifically will be the primary person handling my case, and what is their level of experience? This sounds simple, right? But the answer reveals everything about the law firm's structure and how they view you as a client. You see, when you walk into many law firms, especially larger ones, you meet the rainmaker. This is often a senior partner, the one with their name on the door, with decades of experience and a handshake that could crush a coconut. They are brilliant, charming, and they are the face of the firm. Their job is to bring in business, to bring you in. But once you sign that retainer agreement and write that check, your case file often lands on the desk of someone you've never met. It might be a junior associate who graduated from law school a year ago. It might be a paralegal who manages hundreds of cases at once. This isn't necessarily a bad thing. Law firms are built on a model of leverage. A senior partner's time is incredibly expensive, so they leverage the time of less experienced, lower-paid staff to handle the day-to-day tasks. This is how they stay profitable. The problem arises when this isn't transparent. You believe you're paying for the wisdom and experience of a seasoned veteran, but in reality, you're paying top dollar for a rookie to learn on your time, to research issues the senior partner would know off the top of their head. You're paying for their education, and the tuition is your legal bill. Let me tell you a story about a guy named David. David had an incredible idea for a tech startup. He developed a new app for logistics and trucking, and he just secured his first round of seed funding. It was the most exciting and terrifying time of his life. He needed to file for a provisional patent, and he knew he couldn't mess it up. So he found the best patent law firm in the city. He scheduled a meeting with Dr. Eleanor Vance, a legendary figure in intellectual property law with a PhD in computer science and a law degree from Stanford. In the meeting, Dr. Vance was everything he'd hoped for. She understood the technology instantly, she laid out a brilliant strategy, and she spoke with unshakable confidence. David was sold. He hired her on the spot, feeling a massive wave of relief. He was in the best possible hands. A month later, the first invoice arrived. It was substantial. But what really caught David's eye wasn't the total. It was the name listed next to most of the billed hours: T. Galloway. Who was T. Galloway? David had never spoken to a T. Galloway. He called the office, and after being put on hold, he was transferred to a young, energetic associate named Tom. Tom explained that he was handling the preliminary drafting and research for David's patent application. David asked about his background. Tom had been an attorney for all of 18 months. His specialty? Well, he didn't really have one yet. He was still rotating through the firm's different departments. This was his first ever software patent application. David's heart sank. He was paying $400 an hour for Tom to do what was essentially on-the-job training, all under the supervision of Dr. Vance, who billed an additional $900 an hour to review Tom's work that was often full of basic errors that needed correction. He was paying twice for the same job, once for the rookie to do it wrong and a second time for the expert to fix it. His seed funding, which he had guarded so carefully, was being drained away by inefficiency. The brilliant strategy Dr. Vance had laid out was being executed by a novice, and the entire foundation of his company was at risk. This is why you must ask this question up front. You need to pierce the veil. When you ask, "Who will be working on my case?" listen carefully to the answer. A red flag answer is vague and evasive. "Oh, we have a team-based approach here." Or, "Don't you worry, I personally oversee every single case that comes through this firm." These are non-answers. Overseeing can mean anything from meticulously reviewing every document to glancing at a summary report once a month. A team-based approach is meaningless without knowing who is on the team and what role they play. If they can't give you a straight answer with names and titles, it's because they either don't have a clear plan for your case, or they don't want you to know the plan. A green flag answer, a great answer, is one of total transparency. It sounds something like this: "That's an excellent question. I will be your lead counsel and will personally handle all major strategic decisions, court appearances, and negotiations. For the day-to-day work, like drafting initial motions and handling discovery requests, my associate Jennifer will be taking the lead. She has been with me for 6 years and has handled over 50 cases just like yours. She is brilliant, and using her for these tasks will be much more cost-effective for you. Our senior paralegal, Mike, who has 20 years of experience, will handle all the court filings and scheduling. I personally review and sign off on every single piece of work before it ever leaves our office. In fact, Jennifer is just down the hall. Let me see if she has a moment to come in and say hello. Do you see the difference? That's not a sales pitch. That's an operational plan. It shows confidence, it shows a clear process, and it shows respect for you and your money. It tells you they have a system in place designed for efficiency and success. But don't stop there. Once they've told you who is on the team, you have your follow-ups ready. If they mention an associate, ask, what is their specific experience with this type of legal matter? Ask, who is my primary point of contact? If I have a question or an emergency, do I call you or the associate? And here is a killer question most people never think to ask. How is communication between team members built? If you and your associate have a 10-minute meeting to discuss my case, am I getting billed for both of your time? The answer to that question alone can reveal a firm's entire billing philosophy. A good firm will have a policy against double billing for internal communications, or they will be upfront about how it's handled. By asking these questions, you are not being difficult. You are being a responsible, engaged client. You are establishing yourself as a partner in your own legal journey, not just a passenger. You are setting expectations for communication, transparency, and accountability from the very first day. This single act of asking who is on your team and what they do can prevent the #1 source of conflict between lawyers and clients: surprise bills and the feeling of being passed off to a stranger. Knowing who is on your team is the first step. The next is knowing how you will hear from them. Because the most brilliant legal mind in the world is useless to you if they go dark for 3 months, leaving you to stare at the ceiling at 3 a.m., wondering what on earth is happening with your case. The single biggest complaint clients have about lawyers, more than losing a case, more than the high cost, is the black hole of silence. The next question we're going to cover is designed to destroy that black hole before it ever forms. It forces the lawyer to commit on record to a specific communication plan, so you are never ever left in the dark. And so, you arrive at question number 2. This isn't just a question, it's a contract. It's a verbal and psychological handshake that sets the entire tone for your relationship. You look the lawyer in the eye and you ask, what is your firm's communication policy, and how specifically will we communicate about my case? This question is the antidote to anxiety. Let me be blunt, the #1 complaint clients have about their lawyers, more than losing a case, more than the high cost, is a lack of communication. It's the feeling of screaming into a void. You've handed over the most stressful problem in your life, you've written a huge check, and in return you get silence. You start to wonder, are they working on my case? Did they forget about me? Did I make a horrible mistake? This single question is designed to preemptively solve that entire nightmare. Now, pay very close attention to the answer, because it will tell you everything you need to know. A bad lawyer, or just a disorganized one, will give you a vague, dismissive answer. You'll hear things like, oh, don't worry, we'll be in touch. Or just give the office a call if you have any questions. Or my personal favorite, no news is good news. Let's dismantle these red flags right now. We'll be in touch is not a plan. It's a platitude. It means nothing. Just give us a call. Puts the entire burden of communication on you, the client. It forces you to be the squeaky wheel, constantly chasing them for information you have a right to know. And no news is good news? That is, without a doubt, one of the most toxic phrases in the legal profession. In a legal case, no news can mean a missed deadline, a forgotten filing, or a competitor outmaneuvering you while your case collects dust. It is a massive waving red flag that this lawyer does not have a proactive system for managing their cases or their client's emotional well-being. A great lawyer, on the other hand, will welcome this question. They'll likely lean forward, maybe even smile, because it shows them you're a serious, engaged client. Their answer won't be vague. It will be a system. It will sound something like this. That's an excellent question. Here's how we handle communication. You will have a primary point of contact, my paralegal Jessica. She is copied on all correspondence and is your go-to for day-to-day questions and scheduling. Her job is to respond to all emails and calls within 4 business hours. For more substantive legal questions or strategic discussions, you'll speak directly with me. My policy is to return all client calls and emails within 24 business hours. You will never wait longer than that for a response from me personally. Furthermore, we believe in proactive updates. On the first Friday of every month, you will receive a written summary of your case status through our secure online client portal. This will happen even if there are no major developments, just so you know we are actively monitoring your file and you have peace of mind. Any major event, a court filing, a significant letter from the opposing side, a settlement offer, will trigger an immediate phone call from me, not an email. We will discuss it in real time. Finally, regarding billing for communication, we don't bill for quick administrative calls or emails under 5 minutes. You will only be billed for substantive conversations where we are discussing strategy or legal advice, and that will be clearly itemized on your monthly invoice. Does that process work for you? Do you see the difference? It's night and day. One is a dismissive pat on the head, the other is a comprehensive system designed for clarity and client confidence. It's a roadmap. It tells you who to talk to, when to expect a response, how you'll get updates, and how you'll be billed for it. This is what you are looking for. This is the gold standard. Let me tell you a quick story about two people. Let's call them David and Maria. Both were involved in similar, complex partnership disputes. David hired a lawyer who was a bulldog in the courtroom, a real shark. In the first meeting, David was blown away. He paid the $20,000 retainer and left feeling confident. Then the silence began. A week went by. 2 weeks. David called and left a message. No reply. He emailed. Nothing. A month later, panicked, he called again and finally got the lawyer on the phone, who sounded annoyed and said, "I told you I'd call if there was news." For 6 months, David lived in a state of perpetual anxiety. He had no idea what was happening. He'd wake up at 3 a.m. wondering if his life's work was crumbling while his lawyer was asleep. His case felt like a car he'd dropped off at a mechanic with no windows, with no promise of a pickup time. Now consider Maria. She hired a lawyer who, in their first meeting, laid out the exact communication plan I just described. Maria knew her point of contact. She knew she'd get an update on the first Friday of every month. She knew if a settlement offer came in, her phone would ring. In the third month of her case, an important deadline was approaching. But Maria wasn't worried. Why? Because on the first Friday, just like clockwork, she got an email through the portal. "Hi Maria, just a quick update. We are preparing the summary judgment motion, which is due on the 28th. We have all the documents we need from you at this time. We will send you a draft for review by the 20th. No other major updates at this time. We'll be in touch soon." Maria could breathe. She could focus on her business, her family, her life. She wasn't spending her days chasing her lawyer. She was living her life, confident that her case was being handled professionally. David and Maria had the same type of legal problem, but their experiences were wildly different. David's lawyer created anxiety. Maria's lawyer eliminated it. Your goal is to hire Maria's lawyer, and this question is how you find them. So, when you ask this question, you're listening for specifics. Don't let them off the hook. If they say, "You'll get regular updates," your follow-up is, "Great. What does regular mean to you? Is that weekly, monthly, quarterly?" If they say, "My assistant can help you," your follow-up is, "What is your assistant's name? And what is the firm's policy on her response time?" You are defining the terms of the relationship. You are establishing yourself as a partner in your own legal journey, not a passenger. This isn't about being needy or annoying. It's about professionalism and clarity. A good lawyer will respect you for it, and a bad lawyer will be revealed by it. Getting this commitment, this communication contract, is arguably as important as their legal strategy itself. Because a brilliant strategy is worthless if it's executed in a black hole of silence, leaving you stressed, powerless, and in the dark. Once you've locked in this communication plan, you've built the foundation of trust. You know how and when you'll hear from them. But this brings us to the next, and often most uncomfortable, part of the conversation. It's the single biggest source of conflict between lawyers and their clients. We're talking about the money, not just the hourly rate they quoted you, but the real total all-in cost. The next question we're going to cover is designed to pull back the curtain on every hidden fee, every surprise charge, and every confusing line item on your bill, so you know down to the penny what your legal representation will actually cost you. And so you walk into that office, you sit down across the desk, you look them in the eye, and you ask question number 3. Can you provide me with a comprehensive written breakdown of all potential fees and costs associated with my case, from start to finish? Notice the specific words used there. Not just "What do you charge?" That's a rookie question that gets you a rookie answer, usually just an hourly rate that tells you almost nothing. We're asking for a comprehensive written breakdown. We're asking for the full map of the financial minefield we're about to walk into. This question isn't just important. It's the financial armor that protects you from a catastrophic surprise later on. Because let me tell you, the number one reason for disputes between a client and their lawyer isn't a bad outcome in court. It's a shocking bill that arrives in the mail, a bill that feels like a betrayal. This question prevents that. A good lawyer will welcome this question. They'll see you as a serious, prepared client. A lawyer who gets defensive, who gives you vague answers like, "Oh, we'll cross that bridge when we come to it," or "It's really impossible to say," is waving a giant red flag. Run. Don't walk. So let's dissect what you're actually asking for. The answer to this question has two fundamental parts: the attorney's fees and the case costs. They are not the same thing, and confusing them can cost you thousands. First, let's talk about the attorney's fees. This is what you pay the lawyer and their firm for their time, their skill, and their expertise. This typically comes in one of four flavors. The most common is the hourly rate. This sounds simple, but the devil is in the details. You're not just asking for the hourly rate, you're asking for every hourly rate. The senior partner who oversees the case might be $600 an hour. The junior associate doing the bulk of the research might be $300 an hour. The paralegal drafting documents might be $150 an hour. You need to know who is likely to do what type of work on your case and what their specific rate is. Ask them, how do you bill your time? Is it in 6-minute increments? 15-minute increments? A 5-minute phone call could be billed as 15 minutes of their time depending on their policy. You need to know that. If you don't, a flurry of short emails and quick calls can suddenly add up to hundreds, even thousands of dollars you never saw coming. Second, there's the flat fee. This is more common in straightforward, predictable cases, like an uncontested divorce, a simple will, or a basic bankruptcy filing. The lawyer quotes you one single price to handle the entire matter. The beauty of this is predictability. You know exactly what you're going to pay, but you still need to ask the critical follow-up. What specifically does this flat fee cover? And more importantly, what does it not cover? Does that flat fee for a divorce include drafting the final agreement? Yes. Does it include 3 hours of negotiation with the other side? Maybe. Does it cover the case if it suddenly becomes contested and has to go to trial? Almost certainly not. You need to know precisely where the flat fee ends and where hourly billing might begin. Third, we have the famous contingency fee. You see this all the time in personal injury ads. No fee unless we win for you. And it's a powerful tool for justice, allowing people to take on giant insurance companies without any upfront money. The lawyer takes a percentage of the final settlement or verdict, typically between 33% and 40%. But here is the multi-thousand-dollar mistake almost everyone makes. They think no fee means no cost. It absolutely does not. The attorney's fee is contingent on winning. The case costs are not. We'll get to those in a second, but you could win your case, get a settlement, and after the lawyer's percentage and all the case costs are deducted, you could be left with far less than you imagined. So you must ask, is your contingency percentage calculated before or after the case costs are deducted? The difference can be enormous. Ask them to run a hypothetical example for you. A good lawyer will do this happily. Finally, there's the retainer fee. This is one of the most misunderstood concepts in law. A retainer is not a down payment on a fixed price. It is a lump sum of money you pay up front that the law firm holds in a special trust account. They then bill their hourly fees and costs against that money. Think of it like a debit card for your legal case. When the balance gets low, you'll be required to replenish it. This is called an evergreen retainer. You must ask, what is the initial retainer required? And under what circumstances will I be required to replenish it? What is the minimum balance you require me to maintain in the trust account? Without knowing this, you could be hit with a sudden demand for another $5,000 or $10,000 just to keep your case moving forward. Now, that's just the first half of the equation. The second and often more shocking part are the case costs. These are the out-of-pocket expenses required to run your case. The lawyer pays for them upfront and then bills you for them. This happens under every fee structure, hourly, flat, and yes, even contingency. What are these costs? First, there are the basic administrative costs. Filing fees paid to the court, which can be hundreds of dollars. The cost of a process server to formally deliver documents. The cost of photocopying, couriers, and postage. It sounds trivial, but on a document-heavy case, this can add up to a shocking amount. Then you have the big-ticket items. Discovery costs. This is the process of gathering evidence. It might involve depositions, where you question witnesses under oath. For that, you have to pay for the court reporter's time, which can be $1,000 a day or more. Then you have to pay for the transcript of that testimony, which can be another several $100s per witness. Want it on video? Add a videographer fee. And the biggest one of all, expert witness fees. In many cases, medical malpractice, complex financial disputes, serious car accidents, you need an expert to analyze the evidence and testify on your behalf. These experts are doctors, engineers, forensic accountants. They are the best in their field and they charge for it. Their fees can range from $500 to over $1,000 an hour. A single expert witness can easily add $20, $30, even $50,000 to the cost of a case. Under a contingency fee, if you lose your case, you might not owe your lawyer a dime for their time, but you absolutely will be on the hook for that $50,000 expert witness bill. This is the hidden trap that has financially ruined people who thought they had a no-risk case. So when you ask for the breakdown, you're asking for all of this. You want a written fee agreement that clearly outlines the hourly rates or the contingency percentage. You want a separate, written estimate of anticipated costs. Ask them to break it down by the phase of litigation. What do you estimate the costs will be for the initial investigation? For the discovery phase? For trial? A seasoned lawyer has handled cases like yours before. They know what it takes. They can give you a realistic, good faith estimate. If they can't or won't, it tells you one of two things. Either they don't have enough experience to know, or they don't want you to know. Either way, it's a terrible sign. By asking this question, you are not being difficult. You are being a responsible partner in your own legal matter. You are establishing a relationship built on transparency and trust, not on a handshake and a prayer. You are turning a terrifying, unknown financial obligation into a manageable, predictable business transaction. This clarity is everything. It allows you to budget, to plan, and to focus on the merits of your case instead of lying awake at night dreading the arrival of the mail. Now that you have a crystal clear understanding of the financial commitment, you need to know exactly how you'll be kept in the loop as your case progresses. The next question is designed to tear down the wall of silence that so often exists between a lawyer and their client, ensuring you are never left in the dark, wondering what's happening with the most important case in the world, yours. And so we arrive at question number 3, arguably the one that prevents more heartache, frustration, and outright anger than any other. This is the question that separates the professional from the amateur, the partner from the ghost. Because the number one complaint clients file against their lawyers with state bar associations isn't about losing a case. It's not about legal fees. It's about a complete and total breakdown in communication. It's the feeling of being abandoned, of screaming into a void while your life hangs in the balance. This question is your insurance policy against that feeling. You lean forward, look them directly in the eye and ask, "What is your firm's communication policy?" If their answer is a casual, "Oh, just call me whenever," or "We'll be in touch when something happens," that is not an answer. That is a colossal red flag waving in a hurricane. That is the sound of future you. 3 months from now, leaving your 5th unreturned voicemail, your stomach churning with anxiety, wondering if your lawyer even remembers your name. You are not hiring a friend who you can just text whenever. You are retaining a professional service provider for one of the most critical events of your life. They must have a system, a real defined professional system. Let me tell you about a man named David. David was launching a tech startup and needed to sue a former partner who had stolen their source code. He hired a lawyer who was a bulldog in the courtroom. Sharp, aggressive, brilliant. In their first meeting, David was blown away. He wrote a massive check for the retainer and felt confident. Then silence. A week went by. 2 weeks. A month. David would email, and 2 days later he'd get a one-sentence reply from a paralegal. "We are monitoring the file." He'd call and be told the lawyer was in a meeting and would call him back. The call never came. David started to panic. He had no idea what was happening. Was a lawsuit filed? Had they sent a demand letter? Was the other side responding? He felt completely powerless, like a passenger on a plane in a nosedive with the cockpit door locked. He was paying tens of thousands of dollars to be ignored. After 2.5 months of this agonizing silence, he finally got his lawyer on the phone, who sounded annoyed by the interruption. The lawyer casually mentioned, "Oh yeah, the other side's counsel reached out with a preliminary settlement offer about 6 weeks ago. It was a lowball, so I didn't bother you with it." David's blood ran cold. A settlement offer? Any offer was a starting point for negotiation, a chance to end the bleeding and get back to building his company. But his lawyer, in his infinite wisdom, had made a unilateral decision to reject it without even telling his client it existed. That single act of supreme arrogance, born from a broken communication policy, cost David an extra year of litigation, another $100,000 in legal fees, and nearly destroyed his company. The silence wasn't golden. It was a cancer that ate his case from the inside out. You will not be David, because you are going to get a specific, detailed answer to the communication question. A great lawyer's answer will sound less like a casual promise and more like a service-level agreement. It will cover 5 key areas, and you need to listen for all of them. First is cadence. How often will you hear from them? A top-tier professional will proactively set the rhythm. They'll say something like, "You will receive a status update from our office every single Friday afternoon by email." Even if the update is, "There have been no new developments this week, you will hear from us." This way, you're never left wondering. This simple promise is a cure for legal anxiety. It replaces the fallacy of no news is good news with the certainty of no news means there is literally no news, and we'll talk again next week. Second is the channel. How will you communicate? Is email preferred for documentation? Are phone calls reserved for urgent strategy discussions? Do they use a secure online client portal where you can see documents and calendar dates? A vague just get in touch policy leads to chaos. A great lawyer will define the lanes. For scheduling and administrative questions, my paralegal Jessica is your point person, and she's best reached by email. For any legal strategy or substantive questions about the case, you schedule a call with me directly through Jessica. This ensures your questions are answered efficiently by the right person. This brings us to the third and most crucial point, the contact. Who will you be talking to? You are sitting across from a partner, a senior attorney whose name is on the door. But will you ever speak to them again after they cash your retainer check? This is a deal breaker. You need to ask directly. Will you be my primary point of contact for the legal strategy of my case? Or will it be handed off to a junior associate? It is perfectly normal and efficient for a paralegal to handle paperwork, or for a junior lawyer to draft routine motions. But the brain you are paying for, the experienced strategist you are hiring, must be accessible to you. If they can't promise that you are paying for a brand name but getting a rookie, the answer you want to hear is, "While my team will handle day-to-day administrative tasks to keep your costs down, all strategic decisions are mine, and I am your point of contact for the substance of your case." Fourth is the clock. What is their guaranteed response time? In a world of instant gratification, you can't expect your lawyer to text you back in 5 minutes. But you absolutely can and should expect a professional standard. A good firm will have a clear policy. We guarantee a response to every client email and voicemail within 24 business hours. This isn't just a promise, it's a reflection of how they run their business. It tells you they are organized, they respect their clients, and they have systems in place to ensure nothing falls through the cracks. If they hesitate or can't give you a specific time frame, it tells you they don't have a system, and your message is likely to end up at the bottom of a very messy pile. And finally, the fifth and often overlooked area, cost. You must ask, how is communication billed? This question can save you thousands of dollars. Are 5-minute phone calls rounded up and billed as 15 minutes? Is every single email, even a one-word reply, billed as a minimum increment? A transparent lawyer will be upfront about this. They'll say, all of my time, including responding to emails and phone calls, is billed in 6-minute increments, which is 1/10 of an hour. You will see a detailed breakdown of every charge on your monthly invoice, so there are never any surprises. Someone who gets defensive about this question is someone who is planning on surprising you later. So when you ask, what is your communication policy? You are not being needy. You are being a smart consumer. You are establishing the rules of the relationship from day one. You are testing their professionalism, their organization, and their respect for you as a client. The quality of their answer is a direct predictor of the quality of your experience. A clear, detailed, and systematic answer tells you that this lawyer understands that their job isn't just to practice law, but to guide a human being through a terrifying and confusing process. They understand that communication isn't an interruption of their work. It is a fundamental part of it. Once you have this assurance, once you know exactly how and when you'll be kept in the loop, a huge weight is lifted. You can now trust the process. But there's another layer to this. You see, when you hire a lawyer, you think you're just hiring that one person sitting across the desk from you. But you're not. You're hiring an entire team, a small army that will be working on your behalf. And the next question is designed to pull back the curtain and reveal who those other soldiers are, the hidden players whose skills or lack thereof could secretly determine the outcome of your entire case. And so you must ask the third essential question, a question that cuts through the polished veneer of the senior partner's office and gets to the heart of how your case will actually be handled. That question is, who other than you will be working on my case, and what are their qualifications? This might sound like a simple logistical question, but it's a strategic X-ray into the law firm's very soul. Think of it this way. When you need heart surgery, you focus on the lead surgeon, right? Their reputation, their success rate, their steady hands. But that surgeon doesn't work alone. There's an anesthesiologist controlling your life support, a surgical nurse who knows the procedure as well as the surgeon, and a team of residents assisting. If any one of them makes a mistake, if the anesthesiologist miscalculates the dosage, if the nurse hands over the wrong instrument, the lead surgeon's brilliance becomes irrelevant. The entire operation can fail. A law firm is no different. The lawyer you meet with is the lead surgeon, but their success is fundamentally tied to the quality of their team. Let's start with the most important and often most overlooked player, the paralegal. A great paralegal is a law firm's secret weapon. They are the sergeants in your legal army. They're not lawyers, but they are highly trained specialists who handle a massive amount of the critical, detail-oriented work. They draft motions, organize thousands of pages of documents, manage deadlines, and are often your primary point of contact. A seasoned paralegal with 10 years of experience in your specific type of case can be more valuable day to day than a brilliant but inexperienced associate. They've seen every trick the other side might pull. They know the court clerks by name. They are the engine room of the ship. I once saw a multi-million-dollar business dispute turn on the work of a single paralegal. The opposing counsel had buried a single sentence, a tiny admission of fault, on page 847 of a 2,000-page document dump. The lawyers focused on the grand legal strategy missed it. But the paralegal, a woman named Carol who had been doing this for 25 years, had a system. She was methodical, relentless. She found that sentence at 2 a.m. That one discovery shattered the other side's entire defense and forced them into a massive settlement. Conversely, I've seen cases implode because a new, overwhelmed, or frankly incompetent paralegal missed a filing deadline by one day. One single day. And just like that, a valid claim can be thrown out of court forever. So when you ask about the team, you need to hear about their paralegals. Are they experienced? Are they dedicated to this practice area? A good lawyer will speak about their paralegal with immense respect and pride. A dismissive answer is a blaring red flag. Next, you have the junior associates. These are the newer lawyers at the firm. They'll likely be doing a lot of the heavy lifting on your case, the legal research, writing the first drafts of briefs, handling discovery. This is where the single most common and dangerous law firm tactic comes into play, the bait and switch. It happens every single day. You go into a meeting with the firm's founder, the one whose face is on the billboards. He's charismatic, confident, and promises you the world. You're sold. You sign the retainer agreement, write a huge check, and feel a wave of relief. Then he vanishes. You call the office and get routed to a junior associate named Tom, who just passed the bar 6 months ago. You've never met Tom. You've never even heard of him. He's now in charge of your life-altering legal battle. Every question you have is met with, let me check on that and get back to you. Your case, which you entrusted to a seasoned general, is now being led by a fresh-faced lieutenant who has never seen combat. This isn't to say junior associates are bad. Many are brilliant, hungry, and will do fantastic work. But you have a right to know who they are before you hire the firm. You need to understand their level of experience and, most importantly, the degree of supervision they will receive from the senior lawyer you're actually hiring. A great senior lawyer acts as a mentor and a safety net, reviewing every piece of work the junior associate produces. A less scrupulous one uses them as a profit center, billing out their time while providing little to no oversight. This happened to a man I know, a small business owner named David. He was suing a massive supplier who had sold him defective materials, nearly bankrupting his company. He hired a downtown firm with a huge reputation, meeting with the top litigation partner. He paid a $50,000 retainer. For the next year, his case was handled exclusively by a first-year associate. Key evidence was lost. Depositions were poorly handled. The associate was simply outmatched by the mega firm on the other side. By the time the senior partner finally parachuted back in, the case was in shambles. David was forced to accept a settlement that was less than 10% of what he was owed. He not only lost his case, he lost his business. The bait and switch didn't just cost him money, it cost him his dream. So when the lawyer answers your question, listen carefully. Do they say, I will be handling all the substantive aspects of your case, but I'm assisted by my associate Jennifer, who has been with me for 5 years and has an incredible track record with these types of motions? That's a great answer. It shows a team structure built on experience and trust. Or do they say something vague like, well, we have a team approach here, and various people will touch the file as needed? That is a non-answer. That's the potential start of a nightmare. You need to press them. Ask follow-up questions. What is the associate's specific experience with cases like mine? Can I meet them? How do you supervise the work done by other attorneys and staff? A lawyer who is confident in their team will welcome these questions. A lawyer who is hiding a bait and switch will get defensive. Beyond the paralegals and associates, there might be others. An of-counsel attorney who is a semi-retired expert in a niche area. A forensic accountant they use for financial disputes. A private investigator they trust for criminal defense or accident reconstruction. The quality of this extended network is a direct reflection of the lawyer's experience and reputation in the legal community. This question also ties directly back to the money, which we discussed earlier. The firm's structure directly impacts your bill. Having a paralegal draft a standard document at $150 an hour is far more efficient than having the senior partner do it at $700 an hour. But this only saves you money if the work is done right the first time. If the partner has to spend 2 hours rewriting the paralegal's sloppy work, you've just paid for the same task twice. Transparency about the team is transparency about your bill. It's about ensuring you're paying for a well-oiled machine, not a chaotic and inefficient assembly line where mistakes are fixed on your dime. So, you're not just asking for a list of names. You're testing the firm's integrity. You're evaluating their operational strength. You're protecting yourself from the devastating bait and switch. You're making sure that the army you hire, from the general down to the foot soldier, is ready for the fight. You need to know that every single person touching your file is qualified, supervised, and dedicated to your cause. Because once you have a clear picture of the team, you need to understand exactly how that team will talk to you. The single biggest source of complaints against lawyers isn't losing a case. It's a total breakdown in communication. It's the feeling of being abandoned, left in the dark, your calls and emails disappearing into a black hole while the clock is ticking and your life hangs in the balance. The next question we'll cover is your shield against this. It's the question that establishes the rules of engagement and ensures you will never, ever be ignored. And so, the fourth essential question you must ask is this: what is your communication policy? This question sounds simple. It sounds almost administrative, like asking where the restroom is. But do not be fooled. This is not a question about convenience. It is a question about sanity. It is the question that draws a bright, clear line between a professional partnership and a one-sided, anxiety-fueled nightmare. Because the number one complaint clients have about lawyers, more than losing a case, more than the high fees, is a total and complete lack of communication. It's the feeling of screaming into a void, of sending emails that vanish, of leaving voicemails that go unreturned, all while your life, your business, or your freedom is on the line. This question prevents that. It's your proactive strike against the silence. It transforms an undefined, stressful relationship into a structured, professional engagement with clear rules. A good lawyer won't just have an answer to this question, they will have a system. A great lawyer will be proud to explain it to you. So when you ask, what is your communication policy? You're not just asking one question. You are opening a diagnostic test on their entire practice, and you need to listen for the answers to these 5 hidden sub-questions. First, who will be my primary point of contact? You might be sitting across from the senior partner, the person whose name is on the door, the legal titan you saw on TV. You hire them, you sign the check, and you never speak to them again. Instead, you're handed off to a junior associate, a paralegal, or a case manager. Now, this is not automatically a bad thing. In a well-run firm, paralegals and case managers are incredibly efficient. They handle the day-to-day logistics, gather documents, and can often answer your questions faster than the lawyer who is in court all day. Can even save you money as their billing rate is much lower. But you need to know this up front. The key follow-up is, under what circumstances will I speak directly with you? A good answer sounds like this. Our paralegal, Jessica, will be your day-to-day contact for scheduling and document updates. She's fantastic and will keep you in the loop. However, I will personally call you to discuss case strategy, before any major filing, before any deposition or court appearance, and to discuss any settlement offers. All strategic decisions will be made by you and me together. That is the answer of a lawyer who runs a team. A bad answer is vague. Oh, we all work on the files together. Or, just call the main line and someone will help you. That's a red flag for a disorganized practice where your case could easily fall through the cracks. Second, how often can I expect to receive proactive updates from your office? Notice the word, proactive. This isn't about how often you're allowed to call them. This is about how often they will reach out to you, even if there's nothing new to report. In litigation, there can be long periods of silence. Months can go by while you're waiting for the other side to respond or for a court date to be set. For a client, this silence is torture. Your mind fills the vacuum with worst-case scenarios. Is my lawyer even working on my case? Did they forget about me? A good communication policy accounts for this. An excellent lawyer will say something like, "You will receive an email update from our office every 2 weeks, on Friday afternoon. Even if the update is, there are no new developments, we are still waiting on X and everything is on track, you will hear from us. You will never have to wonder what's going on." This is not just reassuring. It's a mark of true client service. It shows they understand the psychological toll a legal battle takes. If a lawyer says, "We'll call you when something happens," you need to be prepared for long, anxious stretches of silence. Third, what is the best way to communicate with you? And what is your firm's expected response time? This is about aligning expectations. Maybe you live on email, but the lawyer prefers phone calls. Maybe you want to text, but their firm prohibits it for security reasons. You need to know the rules of the road. Ask them directly. If I have a non-urgent question, should I email or call? Then the multi-million-dollar follow-up. And what is your standard turnaround time for a response? A well-run firm will have a clear policy. Our firm policy is to return all client calls and emails within 24 business hours. This is a beautiful, concrete promise. It doesn't mean the head lawyer will personally call you back in a day, but it means someone from the firm will acknowledge your message and let you know when you can expect a full answer. This single piece of information can eliminate 90% of the anxiety of waiting. If you don't hear back in 24 hours, you know it's okay to follow up. If a lawyer hedges on this, saying, "Oh, it gets crazy, I get back to people as soon as I can," that's a warning sign. It signals a reactive, overwhelmed practice, and you are likely to be the one left waiting. Fourth, and this is a big one, how is communication built? You found a lawyer with a great communication policy. They promise to call you back within 24 hours and provide weekly updates. Fantastic! But what you didn't know is that you're being billed in 15-minute increments for every single interaction. That 2-minute phone call to confirm a date? Billed as 15 minutes. That quick email reply? Billed as 15 minutes. Suddenly, your legal bill is thousands of dollars higher than you expected, bloated with charges for communication. You become afraid to contact your own lawyer. This is the opposite of a healthy partnership. So you must ask, how do you bill for emails and phone calls? What is your minimum billing increment? Some lawyers don't bill for very brief communications. Others use smaller, 6-minute increments. Some may even offer a flat fee structure where communication is included. There is no single right answer, but you absolutely must know what their answer is, so you can control your costs and communicate freely without fear of being nickel-and-dimed into silence. And finally, fifth, what is the procedure for an actual emergency? In many legal situations, a sudden arrest, a child being taken, a temporary restraining order being served, you need help now, not in 24 business hours. You need to ask, if there is a genuine time-sensitive emergency outside of business hours, what do I do? A prepared lawyer, especially in fields like criminal defense or family law, will have a system. It might be an after-hours number that goes to a service or a lawyer on call. It might be their personal cell phone number for true emergencies. The specific system matters less than the fact that a system exists. It shows they have contemplated the worst-case scenarios and have a plan in place to protect you. If they look at you blankly, as if they've never even considered this, it suggests they may not have the experience to handle the unpredictable crises that your case might involve. Think about the story of a small business owner we'll call David. He hired a hotshot lawyer to handle a contract dispute. The lawyer was brilliant in the first meeting, laying out a masterful strategy. David was thrilled. He signed the retainer. And then nothing. Weeks turned into a month. David would call and leave a message with the receptionist. He'd send emails. Radio silence. He started to panic. He assumed no news was good news, that his brilliant lawyer was working silently in the background. He was wrong. The lawyer had missed a critical discovery deadline. The other side filed a motion for summary judgment, and because David's lawyer hadn't submitted their evidence on time, the judge granted it. The case was over. David lost catastrophically, not on the merits of his case, but because his lawyer was a black hole of communication. Now contrast that with Sarah, who was going through a contentious divorce. In her first meeting, she spent 10 minutes drilling down on her lawyer's communication policy. She learned she'd be working primarily with a paralegal named Mike. She learned she would get a secure link to a client portal where all documents and a case calendar were updated. She knew to expect a call from her lawyer the week before any court hearing, and that non-urgent emails would be returned within 1 business day. Over the next year there were long quiet months, but Sarah was never anxious. She could log into the portal and see that work was being done. She got her updates as promised. She wasn't being bombarded with useless information, but she was never ever in the dark. She felt in control of her own case because she had insisted on a system for communication. She had a partnership, not a mystery. This seemingly simple question, is your litmus test for professionalism, organization, and empathy. A lawyer who has a clear, client-focused communication policy is a lawyer who has built their practice around service, not just their own convenience. A lawyer who dismisses it is telling you right to your face that your peace of mind is not their priority. And in the storm of a legal battle, having a lawyer who values your peace of mind is not a luxury. It is a fundamental requirement. It's the difference between navigating a crisis with a trusted guide and being lost at sea, alone. Now that you've established the rules of engagement and how you'll communicate, you need to turn to the substance of the fight itself. You've heard the lawyer's best-case scenario, their winning strategy. It all sounds great, but hope is not a strategy. The most dangerous lawyer in the world isn't the one who is incompetent. It's the one who only tells you what you want to hear. The next question we're going to cover is the one that forces a dose of hard reality. It's the question that separates the honest counselors from the salespeople, and it might be the single most important question for protecting yourself from devastating surprises down the road. Here it is, the 4th essential question. You ask the lawyer to stop thinking like your advocate for a moment, and to step into the shoes of your worst enemy. You look them in the eye and ask, if you were the lawyer on the other side, how would you attack my case? Pay attention to what happens in the room when you ask this. A mediocre lawyer or a pure salesperson will often get uncomfortable. They might wave it off, saying something like, oh, their case is incredibly weak. They don't have a leg to stand on. We're in a fantastic position. They'll give you more reassurances, more platitudes, more of the same confident sales pitch. They are selling you a dream of a frictionless victory. And that should be the biggest red flag you'll see all day. Because in the world of law, there is no such thing as a case without weaknesses. None. A great lawyer, on the other hand, will lean forward. Their eyes will narrow. You'll see the gears turning. They will transform from a comforting counselor into a calculating strategist right before your eyes. They will respect the question because it's the very question they've been asking themselves since they first read your file. This question is a stress test. It tests their honesty, their experience, and their strategic depth all at once. An honest lawyer isn't afraid to give you the bad news with the good. An experienced lawyer has seen enough battles to know exactly where the other side will strike. And a strategic lawyer has already thought through the countermoves. Let me tell you about a small business owner named Frank. Frank ran a successful high-end custom cabinetry business. He poured his life into it. One day, a wealthy client, a real estate developer, refused to pay the final massive invoice of over $100,000 on a completed mansion project, claiming the work was substandard. This was nonsense. The work was immaculate, and Frank had the documentation to prove it. Furious and feeling completely in the right, Frank went to a lawyer we'll call Mr. Smooth. Mr. Smooth was charismatic. He had a big fancy office and an even bigger personality. He looked at Frank's documents and said, "Frank, this is an absolute slam dunk. The contract is ironclad. Your photos are perfect. This guy is just a bully trying to get out of paying his bills. We'll file a lawsuit, and he'll pay up in a heartbeat. He won't want this to go to court." Frank felt a huge wave of relief. He felt vindicated. This is exactly what he wanted to hear. The world was back on its axis. Mr. Smooth painted a picture of a quick, decisive victory. He talked about how they'd not only get the $100,000, but also interest and maybe even their attorney's fees. Frank was so caught up in the vision of this righteous victory that he never thought to ask, how could this go wrong? He never asked Mr. Smooth to put on the other side's hat. So he hired him. Mr. Smooth filed the lawsuit, and the developer didn't pay up in a heartbeat. In fact, he didn't even flinch. He hired a massive, notoriously aggressive law firm, and they didn't just defend the case. They attacked Frank's entire business. They filed a countersuit, not just for the $100,000, but for $500,000 in alleged damages to the project. They claimed Frank's company was a fraud. They issued subpoenas for every single project Frank had done in the last 5 years. They demanded years of his financial records, his emails, his text messages. They scheduled a grueling multi-day deposition where they grilled him for hours, trying to twist his words and make him look incompetent. Frank's slam dunk case had turned into a war of attrition. His legal bills were astronomical, far exceeding what Mr. Smooth had vaguely estimated. He was spending more time with his lawyer than he was building cabinets. His business was suffering, his reputation was being attacked in the community, and the stress was destroying his health. Mr. Smooth, who had been so confident, was now constantly on the back foot. He was overwhelmed. He hadn't anticipated this level of aggression. He told Frank, "I can't believe they're being so unreasonable. This is just a scorched earth tactic." But it wasn't an unforeseeable tactic. It was the standard playbook for a wealthy litigant trying to crush a smaller opponent. An experienced strategic lawyer would have seen it coming a mile away. After a year of this legal trench warfare, bleeding money every single day, Frank was broken. He ended up settling. He agreed to walk away from the $100,000 he was owed, and on top of that, he had to pay his own lawyer nearly $60,000 in legal fees. He won nothing. He lost the money he was owed, he lost a year of his life, and he lost a fortune just to get back to zero. Now imagine if Frank in that first meeting had asked Mr. Smooth, "If you were the developer's lawyer, how would you attack my case?" Mr. Smooth would have been forced to either lie or admit the truth. A truly competent and honest lawyer would have said, "Okay, Frank, here's what they're going to do. They know you're a small business. They're going to try to bleed you dry. They'll file a frivolous countersuit to put you on the defensive. They'll bury us in paperwork, it's called discovery, to drive up your legal costs and wear you down. They'll try to make this so painful for you that you'll be forced to walk away from the money you're rightfully owed. Our strategy, therefore, can't just be about proving we're right. It has to be about surviving their onslaught and finding leverage to force a settlement early, before your costs spiral out of control." Armed with that dose of hard reality, Frank could have made a completely different decision. He could have decided the fight wasn't worth it. He could have tried a different, less expensive approach like mediation first. He could have sought out a lawyer who specialized in fighting these kinds of tactics. He would have been entering the battle with his eyes wide open, prepared for the war that was coming, not just the single battle he thought he was fighting. You are not looking for a lawyer who tells you your case has no weaknesses. That lawyer is either a fool or a liar. You are looking for the lawyer who can identify every single potential weakness, every possible line of attack the enemy might use, and can then articulate a clear, intelligent plan for how to preempt, defend, and counter each one. This question separates the salespeople from the generals. Salespeople sell you the destination, the big win, the pot of gold. Generals show you the map of the battlefield, especially the places where the mines are buried and the ambushes are likely to be set. You don't want a tour guide. You want a general. So you've gauged their experience, you understand the costs, you've seen their track record, and now you've tested their honesty by forcing them to look at the ugly side of your case. You've found a general, not just a tour guide. But even with the best general in the world, a war can be lost if the lines of communication break down. That brings us to our final, and perhaps most crucial question for your day-to-day sanity. It's the question that determines whether you'll spend the next several months feeling informed and in control, or in the dark and full of anxiety. And that question is number 5. What is your communication policy? Sounds so simple, almost administrative, but do not be fooled. The answer to this question is a window directly into the soul of the law firm. It will tell you more about what your life will be like for the next year than almost any other question you can ask. Because let me tell you a secret the legal industry doesn't like to advertise. The number one complaint state bar associations receive from clients about their lawyers is not that they lost a case. It's not that they were incompetent. It's that they never called back. It's about a complete and total breakdown in communication. Imagine this scenario. You've hired a lawyer who came highly recommended. A real legal shark, top of their class, wins every case. You have your first meeting, you hand over that huge retainer check and they say, "Don't worry, we've got this." Then silence. A week goes by. Nothing. You send an email. No reply. 2 weeks. You call and get their paralegal who says, "Mr. Smith is in court, he'll get back to you." But he doesn't. A month passes. You're lying awake at 3 in the morning, your heart pounding. Is someone working on my case? Did they forget about me? Did I just throw away my life savings? This anxiety, this feeling of being utterly alone and powerless, is 1,000 times worse than the legal problem itself. That brilliant lawyer might be working tirelessly behind the scenes, but their failure to communicate has turned you into a nervous wreck. Now imagine the alternative. You hire a lawyer who, in that first meeting, looks you in the eye and says, "Here is how we communicate. I will be your primary point of contact for all legal strategy. For scheduling and document submission, you'll work with my paralegal, Susan, who is copied on this email. Our firm's policy is to return every client call and email within 24 business hours. Furthermore, you will receive a bi-weekly status update by email every other Friday. Even if the update is simply to say no new developments, we are waiting for the other side to respond. That way, you are never left wondering what's going on. Which of those two lawyers do you want in your corner? It's not even a contest. The second lawyer isn't just offering legal services. They're offering peace of mind. They have a system, and a system demonstrates respect. It shows that they see you not as a case file, but as a human being going through a stressful ordeal who deserves to be kept informed. So when you ask, "What is your communication policy?" you are listening for several key components. Let's break down the perfect answer. First, you're listening for the who. Who specifically will be my main point of contact? Is it the senior partner you're meeting with now? Or once you sign on, will you be immediately handed off to a junior associate or a paralegal? There's nothing inherently wrong with dealing with a paralegal for routine matters. In fact, it can save you a lot of money, as their hourly rate is much lower. But you need to know the rules of the game. A great answer sounds like this: "I will handle all the strategic decisions and court appearances. For day-to-day questions and document exchanges, you'll work with my paralegal, Jane. She's been with me for 10 years and knows these cases inside and out. However, if you ever feel you need to speak with me directly, you can always schedule a call." This shows a clear structure and a chain of command. A bad answer is evasive. "Oh, someone in the office will be in touch." Who? When? That's a red flag for disorganization. Second, you're listening for the how. How do they prefer to communicate? Is it primarily by email? Phone calls? Do they have a secure online client portal where you can upload documents and see case updates? A modern, efficient firm will have a preferred systematic method. This isn't about their personal preference. It's about ensuring nothing gets lost. A lawyer who says, "Just text me whenever" might sound cool and casual, but it's a recipe for disaster. Important details can get buried in a text thread. A professional will say, "Email is best for non-urgent matters as it creates a written record for both of us. For emergencies, here is the direct office line that my assistant monitors." They have a process. They've thought this through. Third, and this is the big one, you're listening for the when. What is their expected response time? A confident, well-run firm will give you a specific time frame. "We guarantee a response within 1 business day." This is a tangible promise they are making to you. It sets a clear expectation that you can hold them to. Be very wary of the lawyer who gets defensive or vague here. If they say, "Look, I'm extremely busy with court and other clients, I'll get back to you when I can," what they're really telling you is that you are not a priority. They are preemptively managing your expectations downwards. Run away. You deserve better. Finally, you're listening for the what. What kind of information will I receive and how often? This separates the good lawyers from the truly great ones. Most lawyers operate on a no news is good news basis. They'll only contact you when there's a major development, like a court date or a settlement offer. The problem is, legal cases are 99% waiting. Weeks or even months can go by with no external developments. A great lawyer understands the psychological toll this takes on a client. They will be proactive. They will offer scheduled updates, even if there's nothing new to report. A simple automated email that says, "Just checking in. No new updates on your case this week, but rest assured we are monitoring it closely," is invaluable. It takes them 30 seconds to send but saves you weeks of anxiety. So, when you sit in that chair, remember that you are conducting an interview. You are the employer. You are hiring someone for one of the most important jobs in your life. Don't be intimidated. Don't be afraid to ask the tough questions. Let's quickly recap the 5 essential questions we've covered. 1. Have you handled a case exactly like mine before? This cuts to their direct, relevant experience. 2. Who will actually be working on my case? This uncovers the real team and their qualifications. 3. What is your strategy and what are the likely outcomes? This tests their foresight and honesty. 4. How does your fee structure work and what is the total estimated cost? This brings clarity to the most stressful financial aspect. And 5. What is your communication policy? This reveals their professionalism, their respect for you as a client, and the future of your own peace of mind. These 5 questions are your shield and your sword. They will protect you from the wrong lawyer and help you find the right one. Because finding the right legal representation isn't just about finding the person with the most impressive degree or the fanciest office. It's about finding a guide, an advocate, a partner who not only has the skill to navigate the treacherous waters of the legal system, but who also has the decency to keep you informed about the journey, to answer your calls, and to remember that behind every case file is a human being looking for help. The right lawyer doesn't just win your case. They give you confidence and clarity while they do it. Never ever settle for less.